Mr. Chairman, we are live.
Thank you. We are back, your House Judiciary Committee. We are back to consider two bills that were under consideration this morning. House Bill 140, expungement for restoration of rights, and House Bill 212, criminal record expungement provisions. Kay, will you please call the roll?
Representative Crago.
Here.
Representative Larson.
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Williams. Here. Vice Chairman Washut.
Here.
Representative Yin.
Here.
Representative Swanitzer.
Here.
Chairman Olson.
Here.
Everyone is in attendance.
All right. Clarissa, do we have Mr. Barron in the waiting room by chance?
Mr. Chairman, we do. I will admit him to the meeting now if you would like.
Please, yes. All right, Mr. Barron. So if you want to go ahead and introduce yourself for the record, and then we've got both bills in front of us, 140 and 212, and we ended with your opportunity to make public comment. So I think you're probably one of our last public commenters, but please feel free to speak about both bills. There is a kind of a big amendment on the table for our committee that really narrows the scope of what we're going to be talking about. I mean, I think we're really talking about the felony provision, the misdemeanor provision, and it looks like maybe whether you get 2 or 3 bites at the apple when it's a misdemeanor. Anything beyond that, I feel like the committee's kind of narrowed, but you're certainly welcome to still make comments about those other portions in the bills, but just letting you know where we're at to help you with your comments, Mr. Barron.
Thank you, Mr. Chairman Olson. My name is Joe Barron. I'm the Crook County Attorney in Sundance, Wyoming. I've been elected county attorney there since 1990, and I practice exclusively in that particular territory the entire term that I've been since I've been an attorney. I graduated from the University of Wyoming, and upon leaving law school, started in 1986 as a deputy county attorney. In other than 6 months, I've worked in the criminal field, prosecution throughout this time. I'd like to address a couple comments that I heard earlier, just so the committee has an idea. One of the questions that was raised was, what is the recidivism rate in the state of Wyoming? How well are we doing? Well, a few years ago, I served on a committee with Mr. Blonigan, and in our committee, the Department of Corrections study indicated that the state of Wyoming had the second lowest recidivism rate in the nation. Oregon had the lowest, we had the second. And when I say lowest, I mean best recidivism rate. So obviously what we're doing in Wyoming works, and it has been working for a long time. And so when we go to change things, we need to look at, are we really doing anything that's going to do any good in that? The other question that was asked, just so you're aware, is, and when I first looked at this is for a first offender bill. Only a first offense gets a felony or misdemeanor gets an expungement. I see that's changed, but in any event, just to let you know, most first offenders that are truly first offenders that come to court will get some kind of local jail time, possibly, or 3 years of supervised probation. So from that's generally, there's a law that was recently passed a few years ago where you guys, the state legislature, changed the rule of thumb on probation is 3 years, and that's what we normally see in most of our cases. Historically, expungement was just the governor's right to restore a person's rights. But over the years, the legislature has added various factors to do that. First of all, the expungement law here is for felonies. That just was passed initially in 2011. The misdemeanor one was in 2004. From my practice and what I see, the only misdemeanors that I ever see anybody make a request to get expunged are domestic violence convictions. That's the only misdemeanors cases that come before me that I have to address. And that's generally people want to get their gun rights restored, and they can't do that with a domestic violence conviction. There for a while, it didn't matter if you got an expungement at the state level, the way it was worded. I think they fixed that in 2015, but I'm not certain whether or not the federal government recognizes Wyoming's expungement. The other thing is that who does this law help? It helps convicted criminals. That's who it helps. Who will this law hurt? Who that hurts is future victims of crime. One of the legislators addressed the issue, and I just give you a couple stories because it seems like everybody else gets to tell you stories about things. And so I prosecuted several people, one of which was an employee that embezzled money from her employer. First offense, first time she ever did it. And we could prove 20,000 that she took over to Deadwood to gamble from this particular employer. Under the proposal here would be is that after 3 years of probation, and she did a split sentence, did some jail time, and then did a split sentence for 3 to 5 years. I can't remember. Back then it was probably 5 years is what we normally did. But then under the initial bill, even 5 years, what this allows that convicted person to do is then hide this conviction from future employers. And that's what we're talking about. It doesn't allow future victims, future employers, future people to protect themselves. Another case I had was a lady that took the Little League's money and used it to pay her cell phone bill, her car bill, paid for her Dish Direct TV, and that sort of thing. It was a first offense as well. That particular case, she received a deferral, but if that particular person would receive this here, and under this charge here, if you change this to 5 years, it would, after her probation is up, she could hide that conviction from future employers, future people that check on her background to see whether or not she should do that. The other thing I just so you guys are aware too, is under the felony fine here, also who does this affect? This affects victims. It affects victims whose house gets broken into, burglarized, that sort of thing. And I deal with folks a lot, and one of the most traumatic things to people is when their house gets broken into. And that's a private place, and they are intruded upon. And we hear the stories about how this affects somebody getting a job, but what we don't hear is that when I have to call these folks up and say, this person has filed for an expungement, and let them know. And so what does that mean? That means that what they tell me is that means they're getting away with it. They're not held accountable for their actions, and they're getting away with it. If this was to go to 1 year, or even 5 years for that matter, frankly, that's too soon. The longer that's out, the more forgiving that people become. But this is a dramatic thing. And when you bring this up and you bring this causes that event to be relived in these folks' lives. And they have to relive this. And they're re-victimized because of this. And really, it's that's something that an impact that we have to do. Most folks, when the judge issues a sentence, they want to know that that's over. That's what they get. That's what happens to them, and it's done. But here we have this case where folks are getting there. The other thing is what we hear is that the folks get, they need a second chance. Well, the court systems and county attorneys and everybody else in the system is plumb full of second chances. We have diversion programs where we start out with minors. Schools have diversion programs internally. Neighbors let neighbors do things, get away and forgive and do those things when there's other things that occur. Law enforcement agencies give people a break. They give them a break. If they pay restitution, they go apologize, they do those things. In my case, I have to check on all that because I have all kinds of different law enforcement agencies to see what folks have actually done. So that's not just for minors, that's also for adults. We have a juvenile court system that is focused upon restorative justice. It's focused on the best interests of the child and the public safety and rehabilitation, and it avoids court criminal records. The legislature has passed out, we have 3 laws that are already on the books for deferrals, which means that the adjudications are not entered against an individual. The 713-301, the 35-7-1037, which is for drug offenses, and a deferred under the the domestic violence statute. There's a deferral for that, which just means is people are placed on probation and there's no convictions entered on that. Also, for nonviolent offenders, first offense, their rights are automatically restored, and so they get to vote on that. That's already part of the law. That's 713-105. So now we're talking about expungements here at the end of all this. The County Attorneys Association voted overwhelmingly to oppose any decrease in this particular matter. And when I looked at the proposed changes here to the 5 to 3, in just a short time that I've had between then and now, over half everybody that's responded, and that's over half, have responded, are opposed to any change in the law. They see absolutely no reason to change the law as it hits. It gives the individual sufficient time to find out, and the public to find out, is this person truly reformed? Do they actually really need to have this removed from their record? And the shorter time is not a sufficient time to do that. And the bottom line here is accountability. It doesn't protect the public. It doesn't give the person a chance to prove that they're deserving of it. And it doesn't relieve the victim. It makes the victim relive the event sooner rather than later. And a lot of them feel that the defendant's just getting away with the crime that he or she committed against them. The other thing about it, the other changes on there, it looks like they've removed the changes as far as cutting back on the time frame. That's good. It's hard to get everything, track down victims and do all that in the time frames that are allowed now, let alone cutting them down to 45 days. And so agree with that. And the right to appeal a decision. I've never had to appeal the district court judge's decision in one of these cases, but if they violate the law, then in the ruling that they make, then the state ought to have the right to appeal that ruling of a district court judge in that matter. Thank you. If anybody has any question, I would be happy to answer them.
All right. Committee, questions for Mr. Barron? Yes, please, Representative Oakley.
Thank you, Mr. Chair. Good afternoon or evening, Mr. Barron. I was just wondering, how many, do you have jury trials stacked right now because of COVID?
Yes.
I'm just getting to the burden on the system, which I'll talk about, but I just was gonna, I didn't realize we
You
were
want
gonna
a
do
two-part
this.
question.
What's that?
You want a two-part question.
I didn't realize we were going to do it this evening, but I was going to ask some county attorneys where they're at. I know where we're at as far as how many we have stacked.
Mr. Barron, you can go ahead.
Mr. Chairman, Representative Oakley, yes, we do have trials stacked out right now. I don't have those figures right here in front of me, but it's kind of a moving target.
Follow up, Representative Oakley. Okay. Other questions for Mr. Barron? All right. Thank you, Mr. Barron. We appreciate you on short notice making yourself available to provide us with your testimony.
Thank you for contacting me and letting me do that. Appreciate it.
You bet. Additional testimony, we have not heard from trial lawyers.
Good evening, Mr. Chairman, committee. My name is Beth Lance. I'm with the Wyoming Trial Lawyers Association. We stand in support of House Bill 140, 212, or whatever compromise may come before this court now through amendment. So I will speak just in generalities
a
instead
robe.
of specifics.
I don't wear a robe.
Sorry, did I say that?
Yeah.
Oh,
It's one of, I mean,
I've
it
had 3
probably-
court hearings today,
it
so I
probably- I
apologize.
know. It probably wouldn't be a bad thing, but I do like being a legislator, probably more than I would envision myself enjoying being a judge.
Sorry, Mr. Chair. Well, we're glad you're here in the role you are.
Thank you.
But just briefly, I just want to express that our support comes from the fact that this really is a simple bill, that all of the current requirements in 713-1502 remain, which is to remain, you still have to complete your full sentence, pay your restitution, do everything that the court asks of you before you can petition. Even if the time to petition is sooner, those things all have to be done. All of the notice to victims is still required. That 90 days is here for the prosecutor to respond and to gather that information from any potential victims. I know there was also some discussion over taking up courtroom time and hearings, but often expungements aren't brought until they're very likely to be given. And so often they're brought when there is actually agreement from a prosecutor and to the actual expungement. And when there's an agreement and it's presented as stipulated, a hearing is not required. So it would not take up so much of the court's time as to docket a hearing in those situations, which I believe many expungements go through that way. So all of those things are still here. It is a positive for people to be able to turn their life around, to restore their rights, which is good for, employment, families, and our economy. And so I think all of those things are positive, and having whatever amount of a shorter timeline to allow someone to come before court and ask for that, I think is positive overall. Certainly, all those backstops are here, though. A court may or may not deem that that person is actually worthy at that point in time. And so certainly it may be denied, but I think it's positive to provide the opportunity, because I think there are some cases in which people are very well deserving on a sooner timeframe than others. I would stand for questions.
Representative Washit.
Thank you, Your Honor.
I got demoted.
You heard the testimony of Mr. Barron a moment ago, where he cited 713-105, restoration of rights for nonviolent felons. It seems that addresses many of the concerns of convicted felons. Could you address that from your perspective?
Ms. Lance?
Mr. Chair, Representative Washit, it has been some time since I have reviewed that statute. I'm sorry, I'm not totally familiar with the differences between expungement and restoration, but my understanding of expungement, the thing that is most advantageous for the person is that clean criminal record. So if all you have is this one criminal conviction on a criminal record, that's what expungement does for you, is it cleans that record, which is primarily advantageous for you when seeking employment. So that's why that becomes so important. But certainly once you have an expungement, would then be eligible to move forward also with restoration of rights as well. So that's my understanding of that.
Ms. Lance, I want to make, so I think there was some comment about, whether it's 1 year or 5 years, that's not enough time. And so I want to make sure I understand the timeline and what it looks like. So we're talking about we're talking about felonies. We're talking about a nonviolent felony that maybe on average in Wyoming is 3 to 4 years in prison. So the individual is sentenced to prison. They serve 4 years. They get out on some supervision. They finish out maybe another year on supervision. So now they're somewhere between 4 and 5 years. And then the clock starts at this point and what we're talking about. So if we're talking about a 5-year provision, we add 5 more years, it's 9 years from the date that the individual was originally sentenced and incarcerated that they could apply for expungement. And that's under the revision of 5 years. Am I understanding that correct?
Mr. Chairman, you are. That is absolutely my understanding. And I have personally filed expungement several times. And certainly that's the first thing I do when representing someone seeking an expungement is I have them bring me their official criminal record and we go through and be sure what that clock is and whether they actually are qualified pursuant to that clock.
Okay. And so just at the end of the day, the clock for this expungement, whether it's 1 year, 3 year, 5 year, or 10 year, as it is in existing statute, doesn't start until you've served out your entire sentence.
That's correct, Mr. Chairman. And also paid restitution, which sometimes you've actually completed, but if it was a type of what we call white collar crime, where maybe you're paying back a significant amount of money, you're still going to have to wait until that's completed as well.
Okay. So in most scenarios, we're probably still looking at a good decade. Under existing law, because it's already a decade, then you add the sentence onto that, the supervision and the potentially paying the restitution, we're looking at more like 15 years or more.
Mr. Chairman, that's correct. And I frequently, most of my people with that situation committed their crime probably 20 years ago. It's often what I have.
I understand. Okay. Vice Chairman Washit.
Thank you, Mr. Chairman. Just so I'm clear, is your understanding of this bill that if a petition is filed for an expungement and the petitioner appears before the court has full discretion to either grant or deny that expungement? The bar for expungement seems to be fairly high, however. Or at least the bar for refusing to expunge seems to be fairly high, that the judge has to find, remember the exact language, something about the substantial risk or threat or something. Substantial, I think, was the word that stuck in my mind. So the judge might have his hands tied a little bit. Can you address the burden of proof, if you will, for lack of a better term, in these petition hearings?
Ms. Lance?
Mr. Chairman, Representative Washit, thank you for your question. And I understand your concern that potentially there is a higher bar. I think that it is my understanding that judges take these into consideration like anything before them, right? They take it very seriously. And I would say particularly depending on the prosecutor's position or a victim that may come before the court as well upon an expungement will weigh, I would think, quite heavily. And I've seen that weigh heavily for judges, but often it has been so much time or the person is so worthy that prosecutors and victims agree. And so you actually see that a fair amount.
Representative
You shouldn't really have to change any sources.
I'm going to assume that we are being heard and we are now back live. So I apologize if out there in the virtual world, but there
Okay,
is just
Representative
something
Yan,
about
You're in charge.
committee number one and room number one. That every time we meet, we blow up the server. So now we're back live. And Ms. Lance, were you responding or did you already respond?
Mr. Chair, I believe I completed my response.
Okay. Representative Provenza, did you have a follow-up?
Not at this time, Mr. Chairman, no.
Aha, okay. And Representative Wanser, did you want to ask a question?
Nope, I'm good, Mr. Chairman.
Okay. All right. Anyone else have any questions for Ms. Lance? Representative Provenza, you do want to ask another question.
Well, thank you, Mr. Chairman. I suppose it's not a follow-up, but maybe a different question. Thank you, Ms. Lance. How many people do you think who are eligible to file for expungement actually do? It just in your broad sense. I mean, I know that's a very difficult numbers game to ask you.
Ms. Lance?
Thank you, Mr. Chair. Representative Provenza, I would say a very small percentage. Obviously, I don't have statistics, but I would think it's a very small percentage. I think we did hear that the Department of Criminal Investigations on average looks at maybe 20 expungements a month, and that's for the entire state. And so when you think about how many people have gone through the criminal system over the past 20 to 40 years, who are in those positions to be petitioning the court, that seems like very few on a percentage basis to me. Obviously, what again still exists in the bills that you were proposing is a $300 filing fee and likely attorney's fees and costs as well in order to pursue this. And so that's in its own way somewhat of a barrier probably to some people.
Committee, additional questions for Ms. Lance? No? All right, Ms. Lance, thank you for your testimony.
Thank you.
Any other testimony from the public? Clarissa, do we have anyone in the virtual world raising their hand?
Mr. Chairman, I do not have anyone else on Zoom.
Thank you. All right. Seeing no further public testimony, I will officially and for the final time close public testimony on these expungement bills. All right. Now that that is done, committee, what is your pleasure, if you know?
Mr. Chairman,
Representative Yin.
so I know we only have to choose one of them, and we have this joint amendment from both Representative Provenza and Representative Wharf. My concern in moving 140 is that we're still going to have that issue of putting in misdemeanors where the title does not include it. So my preference and my motion would be to move House Bill 212 and then make some amendments on it.
Okay.
So I move House Bill 212.
Okay. House Bill 212 has been moved by Representative Yin. Do we have a second? Seconded by Representative Zwanitzer. Did you have amendments?
Mr. Chairman, yes, I mean, I tracked through the bill to amend it to match essentially what is in the joint handout that we just got. And I'm happy to make the motion to do that and walk through for the secretary as well.
Okay. So you have a global motion then? Is that what you want to do?
Pretty much, unless we want to do it part by part. I think my overall thought, just in general, is that in this bill, there's a lot that I think would be really hard to push on the floor, and the joint amendment is pretty clean and handles basically only two things, which is the 2 times for felony and misdemeanors.
Okay, so then your motion is to move is it to move substantively what is captured in the joint amendment?
Correct. And I do have it tracked, so I can do it line by line if the committee would like. Or does it make more sense to do it as a substitute bill?
Ask Representative Wanitzer if I can just do this as a substitute bill. If if it is so substantial that it's basically deleting 10 pages of bill or whatever this is and replacing it with this one page of,
You can't, Mr. Chairman. Mr. Chairman, I believe you can. The question would be, which bill are you substituting it for? Because politically, it does perhaps make a difference with who's co-sponsoring and who's pushing it. Not that I'd ever say that co-sponsors drive public policy, but there's very different co-sponsors in both of these bills, which is intriguing to me in general. But yes, you could substitute bill either, I believe, for sure 212. 140, I do believe might have a,
so if I substitute bill it, it doesn't become a committee bill, right? It stays under the sponsors, or does it fall under judiciary then? I feel like it becomes a judiciary bill.
that's what happens with appropriations most often. So yes, maybe it would just become a judiciary committee bill as a substitute bill for that number. And that would be, that's your request to make it a committee sponsored substitute bill and your committee approved. Yeah. You'd be fine doing that. And it would actually give it probably more weight to pushing it forward. Win-win.
Okay. All right. What is your motion, Representative Yang? What is your pleasure?
I will move what Representative Zwonitzer just said to match House Bill 212 to be a committee bill
Is
with a substitute
committee
bill to match what's on the handout that we were given.
Okay. That is the second agree?
Yeah.
Second agrees. This is a little bit new for our newer members. But let's, and I think if this will make it helpful, I'll certainly allow for division of the motion to take up each provision one by one, if the committee would prefer that, because I know there's probably some differing opinions on, rather than voting the entire amendment down. And if you want to divide any portion of this amendment, or if you're comfortable voting on the whole amendment, I just want to make sure everybody understands what they're voting on. Okay. Can you light your mic? When you speak, can you light your mic? Okay, Representative Oakley, you would like to divide out sorry, I'm looking at the joint amendment. Maybe you're looking at something different?
I'm looking at either the joint amendment or specifically the bill. I don't know if we're still using it, page 2.
Well, this is the joint amendment. Do you have this?
Right, it's not numbered.
Oh, okay, I see.
It's completely out? Yeah. Okay, then if.
Oh, you're talking about, you were curious about the multiple bites at the apple for the misdemeanor?
Correct. If that's out, then I don't have anything to add.
Okay, all right. So then the amendment does everyone have this piece of paper we're calling the joint amendment that is signed by Provenza and Representative Worf? Everyone knows what we at least are discussing. Okay, so what this does is it would says expungement of, okay, so we'll deal with the title in a second, but this addresses the nonviolent felony and misdemeanor convictions. And then simply addresses the non-status misdemeanors from reducing them from 5 years to 3 years, and the nonviolent felonies from 10 years to 5 years. And the only other thing I would add to this is we need to clarify, Representative Ian, the title, the bill title. I understood this to be important to the parties. So I don't know what the bill title would be based on this. This paper doesn't tell us that. So I think we need to clarify that. Expungement of criminal records, revisions, and restoration of rights, or something of that nature. Does that make sense? We don't have a bill title.
Mr. Chairman, I'm happy to use,
Oh, wait, because we are using 212.
Yeah.
So the bill, I'm sorry. So the bill title is Criminal Record Expungement Revisions. Representative Williams.
Thank you, Mr. Chairman. In regards to the title, I just have concern over the signatures that are on the presented amendment for House Bill 140. I am not sure if Representative Worf would be in agreement of changing the title to a document he signed.
Oh, I see. So we're not, so this is just this amendment that you have in front of you with the signatures. This is just instructive for the substance of the bill itself, is not actually the amendment. We could certainly ask Representative Worf about the bill title, but I understood the bill title to be something that was important to the original intent of the bill for Representative Worf. And so that's what I'm discussing, is that the title is Criminal Record Expungement Revisions. And the bill title could be broadened to be Criminal Record Expungement Revisions and Expungement for Restoration of Rights. Representative Worf.
Mr. Chairman, I don't know if it's appropriate or not, but I know we were asked to meet and we met. And what we agreed to do was the one bill would be set back and that the other bill would be moved forward with the amendment as it was presented to you. So this is totally different than what we agreed to. You know, I'm gonna leave it to your committee, but if you're gonna pull in the restoration of rights into her title, to me, that's no different than you pulling in misdemeanors into my title and just saying expungement.
No, so Representative Worf, to be clear, I think what the motion on the table is right now is a substitute bill. So it sounds like, and this still has to be voted on by the committee, but if I understand the motion right, both bills are being abandoned and an entirely new bill is being put in place, a committee bill now.
Correct. And I'm just saying that's not what we agreed to, and we didn't look at that as an option, Mr. Chairman.
Well, and certainly even if this committee, so let me
Yeah.
explain maybe the process a little bit for you, Representative Worf, because that might help. So this substitute bill that's on the table right now, this committee would consider it and vote on it. If they agree to pass out the substitute bill, your individual bill is still in existence. Your individual bill, if it were moved by this committee, could be voted on by this committee. Frankly, 212 wouldn't be able to because it's being substituted into a new bill. So your bill is still live.
Okay.
If that helps with that.
And I'm just, we didn't get a chance to talk, Mr. Chairman, about what we did to explain how we came up with that amendment.
Oh, you're talking about the joint amendment?
Yeah, that joint amendment, that's the discussion that we had. And I just want to make sure that the body understood that before you go, because that was not considered when we talked. And I'm going to defer again to the chairman.
You mean the substitute bill wasn't?
Yeah, that was not an option. We talked about how we pulled
I'm
what
hearing
we
it
did.
I'm hearing it for the first time on the committee right now. It's
Yep.
just the motion that's being made.
Yep. And I just wanted to make the committee aware of, what we talked about and what was the genesis of the amendment that you have before you.
I understand.
Okay.
And I just as a chairman, I think the thing that I struggle with is that when an amendment is so substantial, that's why we have the substitute bill process, is because otherwise, whatever bill it is, whichever bill it is, with this substantial of an amendment, what would happen is my committee would have to explain a standing committee amendment, which is basically an entirely new bill and get an adoption of that before explaining a bill. And my fear is what would happen on the floor would be very similar to what happened in this committee when the original bill, if you were to just look at it online, either bill has all this other stuff going on, and the standing committee amendment would be, this big, and it really does this much. So that's, I think, why the substitute bill probably makes the most sense. I don't know if you've probably seen a substitute bill in process.
I have, Mr. Chairman. We didn't get a chance to talk about that. I want to make sure the committee understood what the process was, how we came up with the amendment that you.
So I
had
guess my
before.
only question for you, Representative Worf, is do you have any input as to the bill title of the substitute bill?
I think it's important, Mr. Chairman, to capture the restitution of rights.
Okay, the restoration of rights.
Yep.
Okay.
And, I'm fine with adding in misdemeanor. Really, all we did is we are expunging and restoring rights. So I think my title is fine, but if you guys feel like it needs to be more reflective of what the title was on the other bill, that's, once again, I'm going to defer to you, Mr. Chairman, your committee.
Okay, thank you, Representative Worf. So back to the committee, Representative Yin.
Mr. Chairman, just to make it clear for everyone, the catch title, the short title, which is right now in House Bill 212, it's criminal record expungement revisions, can be literally whatever we want, almost literally whatever we want. The important part for the rules that matters is the full title, which is lines 1 through 5, right? So that defines what can be in the bill. Changing that in a substantive way makes it open to a point of order where someone can say that it's against the rules to put in something that wasn't in the title. So that's the issue and the reason why I chose House Bill 212 instead of 140. And I'm happy to also include in the amendment for the substitute bill to rename the catch title to expungement for restoration of rights. I think that's perfectly fine.
Does
that's
Representative
friendly.
Wanser, does the second accept
I
the
agree
catch
with-
title
Yeah.
change?
Yeah.
Okay,
Can do whatever.
all right. Committee. Now do we know what we have in front of us? Okay, all right. Any further discussion on the substitute bill or amendments to the substitute bill? Representative Larson.
Mr. Chairman, thank you. I think you're going to have to clarify the motion before you go very much further when we're going to vote. And I'm going to see if I have it correct. We're going to change the beginning title, the short title, to expungement for restoration of rights. We're going to use the title on 212, lines 1 through 5. And then we're going to take House Bill number 140 and use all of it with the amendment.
Maybe.
Okay.
Maybe depends on the, let me explain it from my perspective and you tell me if this makes sense. Okay, so the bill title is, I think, going to be criminal record expungement revisions and expungement for restoration of rights. Or it could, or maybe it was just expungement for, it's just expungement for rest. Okay, so you got that one right. So check, we got that. Okay, and then lines 1 through 5, the bill title is found right here on this piece of paper. Nope, it's 212.
212.
Okay, so it's what's in 212, lines 1 through 5. So you got that one right? Check. All right. And so the last portion of it was, we're going to take what's in, you said, I think that's the part where I really got confused. You're going to take what's in House Bill 140, but you meant the amendment portion, the substance in the joint amendment.
I thought it was all 140 and stick this amendment.
Well, it does stick what's in 140 in there, but then it changes it from 1 year to 5 years. So then the only thing it adds that isn't in 140 is the misdemeanor provision, which is now going to be 3 years instead of 5 years. Yep.
On the same page.
Check.
I went check.
All right. So I was the one that was lost and confused, not you, Representative Larson. And that happens.
Now I think I just want to make sure I'm on your page.
Okay. All right, committee. Does that make sense? Everyone on the same page now? Now Representative Washit is confused.
Mr. Chairman,
Okay.
I thought we were substituting this one page as a single page bill with the change in title and bill description, but not all the rest of the text contained on the 5 pages of 212. And now I'm hearing we're actually going to blend this language into House Bill 212. And if that's the case, I think we ought to do it line by line.
I don't think so. I think I think the only thing that from 212 that we're keeping is lines 1 through 5 on page 1, which is the bill title itself, right? Then you can basically delete everything else in your mind and plug what you just looked at from the 140 joint amendment in. That's the substance of the bill then. And then the title is the title we have right in front of us on the amendment as well.
And then,
The catch title.
Mr. Chairman, then the remainder of the language in 140 goes away? Or
What is the remainder language?
Mr. Chairman?
Yeah,
May. I don't think there
Representative
is any other language.
Yeah, that's
This is the extent of it.
this will be all that's there?
Yeah, because all 140 does is say if you're filing for an expungement of a nonviolent felony, instead of 10 years, it's 1 year. So that's your bottom line on your amendment. Yeah. Amending the same provision.
If this committee had votes to push it out.
If they push both out.
We're back.
It's not a new legislation, it's a substitute. And I only think it gets titled as judiciary. To answer your question, Representative Washit, my understanding is that it gets retitled as a House Judiciary bill, but if it doesn't, it would just be the 212 bill. But I'm pretty certain that's what happens with a substitute bill.
When it goes to the Senate, it would say Judiciary Committee. But in
It will be presented like a standing committee amendment by this committee. The only reason we went to this path is I think it's easier to present rather than the original sponsors would be presenting the bill that they had that was and everything that we took out and where we're at. And I feel like as hard as it has been for us to catch up on what we have in front of us, I think the body would hate us. They'd be very confused. Representative Washington.
Thank you, Mr. Chairman. Just so I'm clear, when we vote on Representative Yan's motion, that's to make the substitution. Do we have a second vote following that, or is the vote to accept it as a standing as the committee bill? The final vote we'll take today. I want to make sure I'm clear if there's two votes or one coming.
Well, I think there's two votes. So that vote will be basically like you're voting on an amendment. And then you have the opportunity to do additional amendments to the substitute bill. And then you have an opportunity to vote on the final bill. All right, committee?
Question on the amendment?
All your new members are really getting broken in right here with this process. I don't think I went through this in my first couple of weeks as a member. Question on the bill or a question on the amendment. All those in favor? Oh, I'm sorry. Kay.
I have a question. How do I record? You're not officially voting that I would need to record?
Right, you're just voting on the amendment, right? now.
Okay, thank you.
All right, committee. All those in favor of the amendment signify by raising your hand. All those opposed? That amendment carries. All right, well, now we're back on the bill. There's additional discussion or amendments to the bill. Representative Larson.
Mr. Chairman, I voted on that amendment. I'm hoping it's what we talked about.
Me too.
You're hoping that too.
Yes, Representative Larson. I think we're on the same page.
Question.
Representative Oakley.
Thank you, Mr. Chairman. Couldn't be easier, but I just wanted to make sure that we don't put an apostrophe after 3 possessive years. It's just plural.
Okay.
That's
I see where you're talking in the written amendment.
right. Yes, Mr. Chair. So if we use that, I just would like that taken out.
Okay, I will note that. Additional discussion or amendments on the bill? All right, question. We're ready to vote on the bill. So Kay, your question was how do you call so it's just your sheet that says 212. And that is literally the bill that you're going to call the vote on.
Representative Crago,
Aye.
Representative Larson.
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Williams, Vice Chairman Washut,
No.
Representative Yin,
Aye.
Representative Swanitzer.
Aye.
Chairman Olson.
Aye.
Mr. Chairman, you have 8 ayes and 1 no.
Okay. And Kay, how do you feel about having tracked that amendment for the substitute bill? Did we make enough sense or
So
not?
I'm sorry. Does this make sense? I mean, this is what you voted on?
Yeah, just cross out the very first paragraph.
Okay.
Bill, and you're good.
Yep. And then for that first paragraph, you're looking at lines 1 through 5 of 212. And if you cross out 140 at the top and write 212, then I think
Okay.
you might have it.
Anything else? You get rid of that apostrophe.
Okay, I'm with you on this one.
All right. Representative Washington.
I think this is what we need to do now. I would move to postpone indefinitely House Bill 140.
Okay. There's a motion to postpone requires a second.
Yeah.
End of discussion.
It's
No.
not debatable.
Okay, it was moved to postpone indefinitely by Representative Washington, seconded by Representative Swanitzer. And you have another motion, Representative Crago? Oh, okay. All right, committee. I think that's it.
Well, you have to vote.
Oh, you have to vote. With the vote details. All those in favor of indefinitely postponing House Bill 140 signify by raising your hand. All those opposed? Motion carries. All right. Oh, is that a roll call vote?
No, no.
No?
it's just a table vote, yeah.
All right. All right. Okay. Yep. That's right. So Representative Wharf, to clarify what that means is your bill is just sitting in the hopper of the Judiciary Committee and come out at a later date. All right. That's it, committee. Thank you for your evening. Thank you, Kay, as well for staying later. No,